Thank you so much for allowing me to join in today's very important conference, and thanks to Missing Children Europe for this invitation. I'm sorry that I'm not with you because I'm in Strasbourg for the European Parliament's plenary session, but I'm not physically present, but I am with you very much in spirit today. I very much welcome this initiative now in its second year and compliment you on your detailed programme that you're having over the coming days. So I wish you very fruitful discussions. 37% of cases dealt with by missing children hotlines last year concerned parental child abductions, of which 60% were cross-border. My role as Parliament's mediator is focused on children, their rights, and in particular finding solutions to this most distressing issue of international parental child abduction. But more importantly, my role is to try and find amicable solutions to the cases that come before my office. I think we all know that high conflict separations and relationship breakdowns are a top risk factor for child abduction. Mediation techniques offer a suitable model for resolving family disputes with a view to preventing child abduction. I think the mantra of prevention being better than cure is really important when it comes to cases relating to children. Mediation is also a very useful option in cases where a child is abducted, allowing parents to maintain their parenting role after a family breakdown has occurred. My role brings me in direct contact with the real-life problems you'll discuss during your conference. The cases that I deal with are distressing and difficult. They usually involve a desperate plea for help from a parent separated from their child. So my job is to help find mutually acceptable solution in the child's best interest, and I want to underline that. Following the unlawful removal of the child from one country to another, from the country of habitual residence by one of the parents. Mediation in these cases is beneficial from two perspectives. Firstly, it provides an alternative path to some family conflicts which otherwise can get caught up in the complexity of cross-border justice. I think this move towards non-judicial means of dispute resolution is particularly effective in the sensitive area of family relations. An agreement reached by the parties during a mediation procedure can avoid the unnecessary relocation of the child. It allows parents to address all issues affecting the family, and it's speedier and less costly and less distressing than court proceedings. Secondly, mediation allows us to move beyond the sometimes heated emotions which follow when relationships break down. The experience gained in my office is helping to identify systemic problems which may require a legislative response. The aim must be to better define and serve the best interest of the child. This is our ultimate objective, and it is a really important one. But its interpretation is not universally agreed. Serving the best interest of the child in cross-border disputes is not easy. If it was, we would not have so many complex, sad and unresolved cases. Respecting national laws is important, but so too is finding solutions where there is a cross-border issue involving two countries and their very separate legal systems. We know we can't harmonise different national laws which are rooted in different cultural traditions, but we are required to build bridges between them and to make those bridges really strong. Today, parental child abductions in the EU fall under two main sets of rules. The Hague Convention on the civil aspects of international child abduction, and this deals with cases between EU member states and non-EU countries that are party to the convention. 93 contracting states, including all EU member states. This convention is a major international instrument and based on a very simple objective in cases of child abduction, the prompt return of the abducted child. The convention is used rather to apply to issues between member states, but as you know, since 2000, the European Union has adopted its own set of rules revised in 2003 in the Brussels 2A regulation. This regulation deals with cases involving nationals of EU member states, and it was designed to resolve some of the shortcomings of the 1980 Hague Convention. However, based on a sample of over 70 cases brought to my attention in just the last 9 months, I can identify several legal and practical problems in the implementation of the regulation and the relevant parts of the Hague Convention. So let me just first list some of the legal issues that arise, like conflicts in court's jurisdiction, definition of wrongful removal, retention of the child, a lack of definition of habitual residence of the child, violation of the right of the child to have access to both parents, violation of the right of a fair trial or fair hearing, frustration or complication of return of the child due to delays in court proceedings and appeal practices. And then there are practical issues that arise, administrative delays at the competent authority, police and judicial levels, timing of decisions and their communication to parents, shortcomings in the implementation of access rights, communication between the parent from whom the child has been removed and the child itself. For the cases I've looked at, it seems very apparent that sometimes one parent who abducts a child to another member state requires and almost obtains an advantageous legal position by doing that. This happens because, contrary to Article 12 of the Hague Convention, there is no automatic and immediate decision by the relevant court to return the child to the left-behind parent in the member state from which it was abducted. Now, this problem arises from the lack of definition of the wrongful removal or retention of a child. The interpretation of what should be considered a breach of rights is not very clearly or consistently applied. There are, as you know, limitations, though, to this mediation procedure that I'm involved in. Its voluntary nature implies that both parents must be willing and open to compromise. However, the sensitivities of the problems involved in these kinds of conflicts can make it very difficult to get the parties to think about the child first and about the child's best interest. Now, provided there are no legal grounds precluding mediation, such as criminal offences or ongoing legal investigations, mediation is a highly advisable alternative to the legal route. So for this reason, I believe we need to learn from each other, with a view to exchanging best practices for our future. Dragging children through the courts is best avoided by using mediation to find amicable solutions in the child's best interest. As a parent myself, the idea that a child is missing, sometimes forever, is frankly unthinkable, just as it must be unbearable for the children involved. We really do owe it to ourselves to seriously address the issues which see so many children go missing. Your conference provides a welcome platform where stakeholders can get together to improve the situation for children and their families. And we need to look at how mediation works in all our countries, where it is well developed, and how we can share experiences. It is vital that policymakers make these connections in order that we can look after our children and our families. Thank you and good luck with your conference.